Good morning. We'll just wait 1 minute till 11:30. Get started.
Morning.
Right. Good morning again. This is the time set for oral argument in Luba number 2025-053, Eisenberg versus the City of Ashland. I'm Board Chair Zamudio. Board Member Wilson is also present today. Board Member Basham is not present and will not be participating in the decision in this appeal. Please mute your audio when you're not speaking. That will help with the recording quality. And I'm not aware of any pending motions in this appeal. Is there anything that the parties need to bring to our attention?
I don't believe so.
Okay, thank you. Nothing from the parties. So oral argument is a total of 30 minutes. Petitioner, you have 15 minutes and may reserve up to 5 minutes for rebuttal. Would you like to reserve any time?
I would like to reserve 5 minutes, please. Thank you.
Yes, of course. And I will keep track of time and ask that you keep track of your own time too. Just to note the clock, which is really out of view on our screen today, is not there for specific timekeeping purposes, but just for reference. An intervener, you'll have a total of 15 minutes for your response. And again, I'll keep track of time, but ask that you keep track of your own time too. Be mindful of that. So with that, petitioner, please state your name for the record and begin.
Liam Sherlock for petitioners. Do you want me to list the petitioners?
No, go ahead. Just you and go ahead. Thank you.
Thank you. Good morning. Petitioners have, I think, articulated their position fairly clearly in both the petition and the reply briefs, but I just want to touch on some key issues on appeal and then, of course, answer any questions that the board might have. First off, on addressing the first assignment of error, the decision overall was in fact made by the Planning Commission and not the City Council. And as the board well knows, it does not have to defer to interpretations of local land use regulations that are made by planning commissions under the Gage v. City of Portland decision. But even if this was a City Council decision, it wasn't the LUBA can't defer to an interpretation that is simply inconsistent with the express language or purpose or policy. And in this case, I think we've shown on a number of points that the decision does violate the Ashland land use ordinance by allowing some development, a residential development on unbuildable slopes where there is otherwise adequate building area or buildable area on the subject property. The standard under 18.3.10.090A is very clear. It says no development shall occur, or all development shall occur on lands defined as having buildable area, and slopes greater than 35% shall be considered unbuildable except as allowed below. Exceptions may be granted to this requirement only as provided under subsection H. An exception wasn't sought under subsection H. Rather, the commission, despite the fact that the map that was provided, the topographical map, shows most of the site is actually less than 35, and there are areas where certainly a buildable residence could have been placed or shrunk down to conform with the 35% requirement. But that didn't happen here. The applicant did not seek an exception under subsection H. Instead, the city approved the site plan and the application based on its finding that the subject property, and I'm quoting from the record at 7, does not have adequate building area of less than or equal to 35% when considering the need to minimize broader disturbance by limiting development of the site to an area as near the existing driveway location as possible, while also providing for site access and vehicle circulation. But that qualifying language isn't in the code. And so what the commission did, in effect, was insert language that it isn't there. I mean, the city council could amend its code to include that type of exception or consideration, but it hasn't done so. And in a quasi-judicial proceeding, um, the commission is simply not in a position to interpret the encoded.
What? So, I mean, the phrase adequate is, uh, I'm curious how adequacy of the buildable area is determined by the city. First of all, like, what do you think is the proper way for the city to determine what adequate buildable area is? That's my first question. I'll have a follow-up depending on your
Yeah, sure. No,
answer.
it's a good question. I mean, adequate certainly would suggest the building itself with sufficient bedrooms and kitchens and whatnot to accommodate a single family need. But here, the adequate building area, I mean, could have been with actually even maintaining the same square footage of the home itself into areas that were less than 35%. I mean, if you look at, I think it's page 12 of our brief, there's a map that shows the site with all the various slope percentages on it, and clearly there is plenty of area that is less than 35%. But the applicant chose to place the building footprint along with the terraces, the swimming pool, the patios, etc., which are another assignment of error, um, and not building in the strict sense of the residence itself on the areas that include the 35% slope, notwithstanding the fact that they could have relocated that or shrunk it to an area that did not violate the plain language of the code.
So
Uh,
if I understand your answer, adequate buildable area can and should be interpreted with reference to a specific building plan. So the applicant can decide, I want a 5,000 square foot building or I want a 1,500 square foot building. This criterion can shift, determine on this specific building plan that's in front of the city.
Absolutely, I think that's a fair.
And then your argument is you have to take that building plan and look where else on the property it could be located. And if it can be located where there's not steep slopes or the 35% slopes, then the city has to require that.
That's right.
Okay.
Yep, yep. And here that could have occurred, and but the city didn't do that based on its insertion of this need to minimize broader disturbance and locate the building next to the existing driveways for site access and vehicle circulation. Well, okay, but those aren't criteria; those aren't standards by which you can violate the 35% minimum. But I think it sounds like the board understands the argument. So um, I will interject that there isn't substantial evidence to back it up either because of that. Why couldn't they have done it? There's no finding that really explains that. Second assignment of error that I'd like to focus on is the flag lot exceeding the 18% maximum grade. The variance language allows for no exception beyond the 15% and except for the 18% absolute maximum on flag lots that are of this nature. So here it's pretty clear that the slope of the driveway averages 24%. And again, that's an average. There are portions that exceed 30%. So there simply isn't a basis for the city to apply a variance to the variance, the maximum specified by the code. And because the commission failed to provide any valid justification for this significantly exceeding this maximum variance, this decision has to be, we argue, remanded or reversed because there's simply no evidence that would allow for an exception to the exception, if you will. The city also ignored its 200-foot maximum driveway limitation. There's no doubt that the driveway exceeds 200 feet. which is why they've sought the variance. And here there's not adequate findings to justify anywhere in the decision how that proposed variance to the maximum length of the flag driveway is consistent with the non-negotiable cap of 200 feet as set forth under section 18.5.3.6060. I see that I think, at my 10 minutes. Is that
No, you've got another minute and your 10 minutes for your
okay?
primary argument if you want to continue. And if Board Member Wilson has any questions, I'd encourage him to ask them now.
Yeah.
Yeah, Mr. Sherlock, if we agree with you that the slope is greater than 18% and that a variance is not allowed, do we need to reach the fourth assignment of error, where you go through the variance approval criteria?
I think it would be there are the fact that I don't think so. I mean, overall, but I would argue that the conditions that were discussed in in that assignment of error, the city's failure to and the applicant's failure to address the relevant criteria, it might be worth taking a look at that, because we do feel like it's a somewhat of a different argument, although clearly related because it's the variance. But overall, Commissioner Referee Wilson, I think you're right. I mean, it's generally, if this assignment 2 is sustained, pretty much answers the question as to whether it can be allowed. So
Okay, thank
I'll
you.
reserve the remainder of my time for rebuttal. Thank you.
Right. You will have 4.5 minutes for your rebuttal, and we'll turn to the intervener for your argument. Intervener, please state your name for the record and begin.
Hi, Chris Hearn, 515 East Main Street, Ashland, for intervener respondents, Brian and Stephanie DeBoer. We disagree, obviously. We believe the Planning Commission's findings found on page 7 through 9 and 10 through 12 of the record reflect substantial evidence supporting the variance granted and the other aspects of the criteria necessary for the application to be approved with the conditions that were applied. With regard to the first assignment of error, the commission found the parcel does not have adequate building area under the 35% slope when considered in the context of access and minimum site disturbance. This is a pre-existing legal law created in 1996, not by the applicant. It was approved by the city and platted and on their city's buildable lands inventory. Having it buildable, supports needed housing, and the slopes have to be considered in the context of minimum site disturbance. Located where it is on a very steep lot, it's located in the bottom quadrant of the parcel. That's all the slope analysis reflects anyway, is that area. And by being located at the end of the only feasible driveway access, it results in minimum site disturbance. Which is critical to what the petitioners propose is that you could excavate the driveway further through the 35+% slopes, deeper into a patchwork of 27 to 30% slopes. And overall, you'd have greater site disturbance than you would if you located the residence and building pad down at the corner of the parcel where it meets the driveway. Also, the public benefit associated here is the condition offered up by the applicants of providing that long sought trail easement. And that pulls the home furthest away from the trail easement located in the upper portion of the parcel. The
I
planning
understand your
commission.
argument. Your overarching argument is that adequate buildable area allows the city some discretion to consider things like overall site disturbance, easement usage, extension of the driveway.
Agreed. I mean, I think the interpretation made by the planning commission for both the variance criteria and to the extent they apply the hillside development standards was appropriate under these circumstances. Those standards are supposed to take into account the whole physical and environmental constraints portion of the code, is, if you look at the purpose and intent, is to find ways to mitigate sites which might otherwise be unbuildable due to topography and other issues, and allow, some give and take to allow those sites to be buildable within the confines of the code.
So ALOU 18.3.10.090.A.1 is within that, under that purpose umbrella, is what your argument is. I'm trying to understand what your argument is specifically with respect to the language of this criterion. I understand your overarching argument, but I'd like to focus on adequate buildable area and what that means. And I think I understand your argument is that the city should look at all of the things when they're determining what is adequate buildable area, whereas petitioner's argument is under the steep slopes provisions, the city should only look at, is there another area that avoids the 35% slopes? So there's a very interpretation
I think
here.
if you look at the topo maps that were submitted by both sides, which only are, again, that lower quadrant of the property, not the entire property, which is extremely steep in the upper part. There's some patches of 27 to 30%, but to get to those, you'd have to excavate the driveway further into the parcel, resulting in much greater site disturbance. So that's our argument on that. We think the findings, of course, are supported by adequate evidence. Second assignment of error, there's just a factual disagreement. The driveway was measured by our engineering staff at 197 feet. The petitioners, they claimed it was over 200 feet. That's just a factual controversy. Evidence on both sides was submitted, and using the substantial evidence rule, it was reasonable for the Planning Commission to choose the 197 feet rather than the 200 feet. It's a difference in measurements provided by two opposing sides. And that's just a conflict in the evidence. It's not a lack of application of the criteria on the part of the Planning Commission.
What is the finding on the average grade?
I think it was 24%. And I say that, by the way, on page 32 of my brief. There was a typo that was pointed out by petitioners on page 17 where I said it was 15.23. That was meant to be 24%. But I mean, that's the whole reason for the variance.
The variance only allows up to 18%. So why, if the fact is that the grade is 24%, why does that not negate the ability for the city to allow a variance at all? Because the variance standard allows up to 18. So if the fact is that it's 24, how can the city do this?
Well, because the commission found the driveway is 197 feet in length with an average slope of 24%, and that no feasible alternative access exists, which is an important part of the code. Those driveway, by the way, the driveway standards are directly under the new lots and partitions portion of the code. So if you're going in with a new lot or partition with a flag lot, you can't show those greater slopes on the driveway. But we're talking about a
Where does the code allow for an exception for a pre-existing lot so that this variance criterion does not apply? Where did the city apply that exception?
Well, I don't know that it specifically has an exception for pre-existing, but it does. The portion of the code that has a standard is no lot line adjustment. I believe it says no lot line adjustments or partitions shall be allowed unless the flag drive meets these standards. And it was.
So the city didn't find that this criterion does not apply. The city found that this criterion was satisfied, right? So those are two really different issues. If the criterion applies and it allows only up to an 18% grade for a variance, how can the city ever approve a 24% grade?
I think if it's a type 1 variance, that's true, but a type 2 variance, I think, can exceed that.
Where in the code is that supported?
Uh, 18.5.3060F allows for variance for driveway grades exceeding 15% provided the variance criteria in 18.5.5 are met, and the length of the driveway does not exceed 200 feet. The staff report explains the proposed driveway configuration meets those criteria, and the type 2 variance approval is therefore consistent with the ordinance. So 18.5.3.060F is where I believe it is.
Right, which provides no greater than 18%. So what you're arguing is that 18% cap doesn't apply because this lot pre-existed the adoption of that code provision. I don't think that the city found that this provision doesn't apply. I think the city found that the variance is allowable. So what's your argument that the city has authority to allow a greater than 18% grade even under this variance provision?
Flag drive shall not exceed 15% grade. This is 18.5.300F. Variances may be granted for flag drives for grades in excess of 15%, but no greater than 18%, provided the cumulative length that a planning commission finds the proposed driveways via an existing shared access easement to utilize an existing long, steep, privately paved roadway. The proposed driveway extension to serve the subject property is 197 feet in total length, and the terminus of the existing driveway has an average slope of 24%. And the commission found the lot configuration, site topography, and existing driveway grade and natural features constituted unique circumstances that prevented the existing lot from meeting the standard, and that adjacent properties to the east exceed 15% grade. Average existing property grade before the driveway construction is 27%, and there's no feasible area to mitigate the driveway grade configuration and the location to access easement. So the commission found that no alternative driveway access was available, and that this is otherwise a landlocked parcel which would be undevelopable if a type 2 variance wasn't granted.
Okay, thank you.
It sure looks like the findings find that you need a variance, but you can't get one. But because there's no alternative means, we're going to give you one anyway. Am I missing something there?
Well, I think they found, it was an exception for a pre-existing parcel that was approved prior to the adoption of the standards.
How does that allow you to not have to meet the variance criteria or standard?
I think that I can't tell you exactly. I'd have to circle back.
Okay.
I think that the purpose of a variance for a pre-existing landlocked lot that was created before the standards existed in a type 2 context allows a little more leniency if the other variance criteria are met. I mean, if the variance criteria are solidly met, which they are in this case.
Okay, thank you.
And it's not a self-imposed situation. The petitioners went through the variance criteria and felt this was self-imposed. If you look at the variance criteria self-imposed, it says, for example, if the applicant had previously done a partition or lot line adjustment that created the situation. So it specifies in the variance criteria code that an example of self-imposed would mean the applicant, his or herself, had led to the had done a lot line adjustment or partition, which led to the variance being required.
And on the fire turnaround, petitioners arguing there was no finding of feasibility that a turnout would satisfy the fire standards, and you point to an email from the fire marshal saying that I'll consider a turnout designed to Jackson County development standards. Petitioner argues that doesn't show that the fire marshal approves that or that it's feasible. It just shows that the fire marshal would consider a proposal for a turnout. What's your argument that that is a feasibility finding, or that is adequate to support a feasibility
finding? It's going to be sprinklered, and the pool will be equipped for outflow to help suppress fire equipment. I mean, wildfire in the event that happens. The fire official, said they'd consider that. I mean, it was adopted then as a condition of approval. There's adequate space for the Jackson County style turnaround, which is, there's adequate space for the applicant to do that.
Did the city find that there's adequate space for that, or did the city just find we can wait for this until we are approving the site plan to have the fire marshal sign off on that? Petitioners arguing there's no feasibility findings and that under Ryan, the city needs to make feasibility findings on this alternative fire vehicle turnaround.
I think that, the fire marshal's submittal along with the engineer's report, which I think found that there was feasible space that could be developed up there to do Jackson County style turnaround if necessary.
Can you point to where in the record that is, or where the city relied on that? It seems
I
like
can't find that specifically.
Okay, you don't have that handy. Okay, so we're at your 15 minutes also. So unless there's further questions from the board for intervener, just a couple sentences to wrap up your argument, Council Horn.
Yeah, I mean, we believe that really if the board focuses on pages 7 through 9 of the record, 10 through 12, and looks at the Planning Commission's findings along with the record, that there's substantial evidence to support the finding in light of the fact that this is a pre-existing lot with no other access available in a very steep area of town that's, and the needed housing concerns for having inventory of housing and utilizing urban infill to make lots developable when they're created historically.
Thank you. We'll return to petitioner. You'll have 4.5 minutes for your rebuttal, petitioner.
Thank you. Just a few points here. One, there is nothing in the code that carves out an exception for pre-existing lots. Under the variance criteria, that would simply create a rather inconsistent application of the code to various development proposals, given that there's plenty of lots in the city that are still vacant or subject to redevelopment. And there just isn't code language that would allow for the board to adopt the interpretation proposed by applicant, which because it's just there's no legal justification for that. On the 200-foot length question, the city staff determined that the length of the driveway is, quote, well exceeds both the 200-foot limit and the 18% grade threshold based on the applicant's own materials. And we cited that in our brief, but it's at record 426 and at 415, where, I mean, the applicant admitted that the proposed driveway exceeds 200 feet in length, which is why they sought the variance for that driveway length. There wasn't just the variance for the slope, the steepness of the driveway. It was also exceeding the 200 foot, and so it's inconsistent now to say that, well, we didn't have to abide by the 200 foot standard because it's not 200 feet. Well, that's not what they say in their application materials. It's not what's clearly indicated in the record. And it doesn't make sense that they would have applied for a variance for that, to that condition.
So what I'm hearing today is essentially the grade is 24%. That exceeds the 18% cap, so it can't be given. You've asked for a reversal based on this criteria. Is the evidence such that there is no way to design a driveway that would be under that 18% cap, or it's just the driveway as proposed is not under that 18% cap?
We, according to the applicant, there is no other way
This
to.
is the only way to
This is
get
the
to
only way
this
to get there.
parcel, to the buildable area.
Yep.
And
That's
where is that in the record?
Uh,
The planning
I mean,
commission
I think, I
found,
mean,
the
I
planning
think,
commission found that that's why the planning commission approved this, is because this is the only way to get to the buildable area. So that
Right.
finding, it should be in the planning commission decision.
yes, and I think, I mean, I think it's fair to say that Mr. Hearn just basically conceded that in his argument, that this is the only way to get there. Along this, I mean, there's easements coming from Granite Street, and then it's a straight shot up to the flag portion of the parcel. And so it's, yeah, I don't think the easements that are in existence would allow for anything other at this point. That's not, I mean, I suppose they could try and get easements from other access points elsewhere, but based on the record, I think it's fair to say, and
My question is really about the proper disposition. If we agree that this variance criterion is not satisfied and you're asking for reversal, I'm essentially asking, what's your best argument that reversal is the best disposition here? And I think I hear you saying, well, maybe there's a different way to get there,
maybe, but I think based on the record, there's no evidence that I'm aware of that shows there was any ability or attempt to do anything other than this attempt to slam through this variance of the 18%. Because I think, I mean, there's certainly no findings to that effect in the decision.
and there may be findings that this is the only way to get there.
I believe there are.
Okay.
I think that is, I don't think that's disputed.
Okay.
Yeah.
Any further questions from the board on this? Okay. That does complete your rebuttal time, but since I gave intervener a couple of sentences to wrap up, I'll also give you a couple of sentences to wrap up your argument.
Oh,
Thank you.
thanks. Yeah, there's no
No,
other.
no intervene. No, I'm not inviting the intervener. I'm allowing petitioner to complete their argument. Thank you.
I think we've set forth, our arguments pretty straightforward in our briefs. I think the board seems to have a pretty good grasp of the arguments at issue. We would ask that the decision be reversed, given that there's absolutely no way to avoid violating the variance statute, variance ordinance, both as far as the 18% in particular, but also the 200-foot length. And and for the other reasons that we set forth in our petition, at the very least, the decision should be remanded.
Thank you.
Appreciate
That will,
your time.
thank you. Thank you for your argument to both of the parties and for answering our questions. That will conclude oral argument. The statutory due date for our decision in this appeal is April 8th. We'll ask the parties to agree to an extension so that we issue our decision by April 29th. Is that okay with these parties?
That's fine with petitioner.
Okay, and I see a nod from intervener. Thank you for that, and have a good remainder of your day.